mode. Option. I, Dr. Manjunath, feel privileged to welcome you all for this very special occasion of workshop and interactive session on intellectual property rights, IPR and IP management for startup, which is organized by CAHER's IPR cell in association with the Institution Innovation Council of CAHER. So to start with the function, may I now request Dr. Anil Koralli sir to convener Institution Innovation Council to welcome our guests for the today's.
A warm greetings to all the dignitaries on the dais and off the dais, and to all the members over here and joined online. Good morning to one and all. I'm more than grateful to stand here and welcome you all to this informative and interactive workshop on intellectual property rights and IP management for startups organized by IPR Cell and Institution Innovation Council of Cayley Academy of Higher Education and Research. Intellectual property rights are the rights that protect the creations of human mind, such as inventions, literary, artistic works, design, symbols, names, and images. IPR are essential for fostering innovation, creativity, and competitiveness in the field of science, technology, arts, business, and healthcare. On behalf of the organization, I would like to welcome our Honorable Vice Chancellor, Dr. Nitin Gangane, sir. I welcome you, sir, for today's event. I also take this opportunity to welcome respected Dr. V.A. Kotiwale, sir, Registrar and Vice President of Institution Innovation Council of Cayley Academy of Higher Education and Research. I welcome you, sir. We are privileged to have with us Dr. Sharan Gowda Patil, who is Deputy Controller General of Patents and Designs and Head of Biotechnology of Kolkata, Government of India, our resource person for today's workshop. On behalf of the organizing committee, I would like to welcome you, sir, for today's event. Welcome, sir. I would like to welcome Dr. Shiyogi, sir, IPR coordinator of IIC, who has taken all the efforts to organize this workshop. I welcome you, sir. I also take this opportunity to welcome all the principals, deans, and all the members of Research and Development Cell of CAHER, members of IQAC, members of Institution Innovation Council, and faculty members and research scholars who have joined here and as well as online for this workshop. So our workshop to create awareness and appreciation of IPR among our participants and to equip them with necessary tools and techniques to protect and manage their intellectual assets. We hope this workshop will inspire you and pursue your creative endeavors with confidence and responsibility. Thank you one and all.
Thank you, Anil sir, for hearty welcome. Dear friends, as a symbol of our admiration and gratitude, we would like to present floral bouquet to our today's speaker, Dr. Sharan Gowda Patil. For this, may I request Honorable Vice Chancellor, Dr. Nitin Gangane, CAHER to present the floral bouquet to the Dr. Sharan Gowda Patil. Thank you, sir. So now move upon. May I request all the dignitaries on the dais to come forward and light the lamp to inaugurate the function.
सम्पदः शुभं कुरुध्वं कल्याणम् आरोग्यं धनसम्पदः शत्रुबुद्धिविनाशाय दीपज्योतिर्नमोऽस्तु ते दीपज्योतिर्नमोऽस्तु ते शुभं कुरुध्वं कल्याणम् आरोग्यं धनसम्पदः.
Thank you, sir. Thank you all. Now, may I request Dr. Shivogi Hoga, sir, the coordinator IPSL, to introduce our today's speaker for the workshop.
Good morning, Honorable Vice Chancellor Sir, Registrar Sir, and all the dignitaries present over here. It gives me an immense pleasure and I am honored to introduce our resource person, Dr. Sharan Gowda Sir, before you all. He has immense knowledge in the field of IPR and is currently working as Deputy Controller of Patents and Design, Biotechnology Group, Patent Office of Kolkata. Along with his master degree, he has completed PhD in biochemistry from Gulbarga University, Gulbarga, LLB from Mumbai University, Diploma in Fostering Innovation and Commercialization of IPR from CBS Copenhagen, Denmark. He has also qualified CSIR UGC NET GATE 1977 and Karnataka SLET in 1997. He has specialized in examining and scrutinizing the patent application based on traditional knowledge and inventions, worked as a member of expert committee on ABS of Biological Diversity Act 2002. He has got the immense knowledge of 19 years in the Patent Office of India and 3 years experience to teach MSc Biochemistry and Biotechnology course. He has got various publications in the international and national journals. He has awarded as a Young Scientist Award from NASA, New Delhi. He has delivered more than 250 lectures regarding IPR and also he has trained various researchers for filing the patent. I welcome you, sir.
Thank you, sir. Thank you for the welcoming the speaker introducing. May I now request our respected registrar, Dr. V.A. Kotiwali, sir, to speak a few words regarding that.
Honorable Vice Chancellor Sir, Dr. Nitin Gangne Sir, today's chief guest, Dr. Sharan Gowda Patil, Dr. Shivogi, Dr. Anil Koralli, all the principals, faculty and students. As we have today workshop on intellectual property right and IP management startup by our university. We being in health university, we have all the faculties, the pharmacy, dentistry, Ayurveda, medical. We are involved in physiotherapy, technologies, laboratory work, our own innovations in the management, our own skills, integration and applications related to technology, related to engineering field, and we integrate to the other faculties. Many things are happening, but we being in our health profession, we involved in our own way, and we don't know how to go ahead and try to document or how to patent it, how to recognize it, and so that whole world knows about that. And we try to find out something, it is very difficult to fill out, and we really miss many things. So in this regard, the accreditation bodies like NIRF, NAC and everything, they are specifically looking into these things so that they can judge without biasing how things are going on in our university in respect to departments and institutes. Considering this, we have been able to awaken. We are very fortunate to have, we have revived everything, and accordingly the committees have been formed. And we are fortunate that Sharan Gowda Patil, who is from our Karnataka and who is a learned and such a phenomenal person who is heading at the Indian government, that Institutional Innovation Council, and is fortunate that he's been coming to us and helping us, our institute, in a very way. And now this time he has taken trouble to come all the way, and having 2 days he has spent in our university. I thank you very much for having spared your valuable time and being with us. And it is our duty that we must utilize his time, how much he has dedicated to that, so that we encash on all the things and get some fruitful results in due course of a time. I wish the workshop great success. Thank you.
Thank you, sir. Thank you very much on your words. Dear friends, we have a such inspiring personality with us today as a president of the function, Professor Dr. Nitin M. Gangane, Honorable Vice Chancellor, KLE Academy of Higher Education Research, Belgavi. Sir, now I request you to give the presidential remark of this one.
Dr. Gauda Patil, Dr. Hugur, Dr. Anil, Kothale sir, COE, Dr. Sunil, and my dear friends. I started hearing about patents and intellectual property rights somewhere when there was claim on new news, right? That was first thing when the newspaper we started to hear about patents. Then I heard about fight for basmati rice, then fight between Bengal and Orissa about who invented Rasgulla. So all these patent activities were we read it in newspapers, right? We never knew that a doctor should be interested in intellectual property rights. All of us are interested in property rights, but not intellectual property rights, right? We are interested in properties, but not intellectuals. Anyway, so somewhere along the line, when I became a dean, then again the question came for patents and copyrights. So again, interest started. We organized a workshop. But let me tell you frankly, I also attended that workshop in spite of being the dean, and I hardly could understand what was going on during the workshop. Basically, the problem with us is, as I told, we are interested in properties but not intellectual property, is because we don't understand the importance of this. When somebody he suggested that he has a right over the neem leaves, it was a major message that even a simple thing like neem leaves, we know that they are beneficial for health. Many of us use neem products, but those neem products could have commercial value. And that commercial value can be exploited by a person who has that patent right. We never understood that. We never anticipated that such thing can happen. So over a period of time, then we understood that for NRF ranking, for NAC, this is important. And that's why that it has generated interest in our faculty, at least medicine faculty, the health science professionals. Then it started that, okay, we have to have patents, we have to have copyrights. So the type of patents, the type of copyrights which are coming out because of this reason for NRF ranking, reason for NAC is a low standard. Let me be very frank. Even we do that. Even everybody does that. All deemed universities, all universities, they do that because they must have some patents. They must have some copyrights. They may not be actually have any commercial value, zero commercial value, but still we make a patent. So somewhere along the line for regulatory bodies also, it is important to understand that just having a patent or just having a copyright is not important, but they must be also having some commercial interest, some profit to be earned from that patent or that copyright. Unless and until they start measuring qualitatively, just quantities are not going to help us. Sir is with us. He was previously in Chennai, then he shifted to Kolkata. But in spite of that, he has shown interest to come here and talk with you, discuss with you, because he's from Northern Karnataka. That is the reason probably he is interested to come to his parents' native place. And because of that interest, he has come. Now it is our interest that we should try to understand from him how the process runs. We know that we don't have anything at present in our mind, but you may, because these young people are there, they are probably post volunteers. They are not actually, have you registered on your own? Young people. Okay, that's good. At least one person is saying that she has registered on her own. So that is okay, but that it has given you opportunity. What I'm trying to say is, see, for your level, nobody is going to organize intellectual property rights workshop. You have that opportunity, so you try to understand, because you have a long career ahead of you. Maybe at my age, to think of a patent or think of a new thing will be difficult. But at your age, there are so many new things which come to your mind, right? We're thinking of this intellectual property right innovations, and then we thought that why we cannot have a hackathon where we just float an idea and you come out with your own ideas to discuss and to discuss with experts in the field. So same thing when you discuss with expert in the field, but the idea is yours. So you will have to patent it, you will have to copyright it. Unless and until you copyright it, somebody else will copyright it. And once somebody else copyrights it, even if you say that, okay, I have done, nobody will listen to you, okay? So that's the reason why I'm saying that this is opportunity for you. Take this opportunity, seriously attend the entire workshop, ask questions to sir, because I know this topic is not, this is somewhat a legal implications, legal things, which we don't understand, isn't it? But try to understand from him how the process goes, what are the problems in that, what are the things which will hamper you during the patenting process, because it is a long process. It is not a process which will, you file a patent and you get next day. That doesn't happen, okay? So try to understand the process, and maybe in your life, of your professional life for next 30, 40 years, you will develop a patent on your own, and maybe that will have a commercial value. You know, Thomas Edison was owner of Edison. You must have about, everybody has heard about Edison. So he had patents, about 1,000 patents, right? That means almost every 15 days you used to make, during that productive period of his life, every 15 days you used to make a patent. And out of those 1,000 patents, 500 patents were international. They were not only patented in US, but they were patented throughout the world, okay? So you can imagine that he was a very good investigator, but at the same time, he was very good commercial entrepreneur, okay? So just having knowledge, just having ideas doesn't work. To work those ideas, to make them happen and to make them commercially viable, okay, if you are very good in nature, you can donate that money later on if you get that money, but at least get that money, okay? So that is the basic idea, that why we are arranging this activity for our faculty as well as our students, is that somewhere along the line they will have some idea and they will make it materialize. Thank you. Best of luck.
Thank you, sir. Thank you for the valuable words. Next, I call upon Dr. Rohan Attri, sir, Professor, Member IPR Cell, to propose a vote of thanks.
Good morning, all. I deem it a great honor and privilege to propose the vote of thanks on this memorable occasion. On behalf of CAHER, I would like to extend a deep sense of gratitude and appreciation towards Dr. Sharan Gowda Patil sir, our chief guest and resource person of today, for accepting the invitation. I would like to thank Dr. Prabhakar Kore, Chairman, KLE Society, and Honorable Chancellor, CAHER, for constant encouragement and support. I would like to thank Dr. Nitin Gangane, Honorable Vice Chancellor, CAHER, Dr. V.A. Kotiwale, Registrar, CAHER, Dr. Preeti Dodwad, Member Secretary, Health Institutions of KLE Society, all the life members of KLE Society for their constant help and encouragement in conduct of all such events. I would like to thank the Research and Development Cell and Institutional Innovation Council, all the members, conveners, and the directors. I would like to thank all the principals, deans, heads of the departments, faculty members, PhD scholars, postgraduate, undergraduate students for their active participation in this workshop. I would like to thank the Civil Electrical Photography Department and members of press and media. Thank you one and all.
Thank you, sir. Now I request all to raise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Thank you, sir. Now we shall begin with the session, first session. So I request Dr. Sharan Gowda Patil sir to start your first session. For online participants, I hope it is screen is visible and we are audible.
Yes, sir.
Kindly mute everyone yourself.
Good morning, everybody. So, it's my privilege and honor to come again and speak in this university on IPR topic. So, and really great to know that many are interested to know IPR. As Vice Chancellor sir was saying, this may be the property, but we generally neglect on that intellectual property. So we are interested in properties, something else, but not the intellectual property. But still today I will talk on intellectual property and its importance which can play in any field, whether it is health profession or that is medical, electronics, mechanical, chemical, in any field of science. So it's a, see, if you compare globally, so in US, the second most patent applications filed for the medical inventions only. First is electronics, the next comes is the health profession or medical inventions, whether it is a drugs or it is a medical or surgical equipments. And when you say the electronic equipments or electronic devices or even the applications, software, programs, so they have a very short life. Because of that, numbers are more in that. So maybe after 3 years, every application or every electronic device may be newly coming and it will be outdated. Like our phones, we are seeing that generations of mobile phones, we are witnessing it. But in health profession, if you take, it has a longer life. Even some patents exist for 20 years also, like blockbuster drugs. So they have a period up to 20 years. Even after 20 years also, they have a commercial value. So especially the life-saving drugs. So it is the most having the life of a patent in the health profession, which in my experience I can say that. So that is why it is important, even the professionals who are doing any type of creations in the health or profession or medical inventions, we generally refer them. We have different categories like mechanical, electronics, chemical, health, pharma, like that. So many divisions in patent office also. We examine accordingly those who are related to that. So I am a biochemist, so I generally get biochemistry and biotechnology applications only. I will never examine other than that. Like biomedical inventions, I will not look into that. We can understand, but we require expertise in that. We are trained, we train our examiners like that. So to deal with certain subject area, those who are in that subject, they can easily grasp it. So this may be many young professionals who are is IPR and from where it comes. So this, as Vice Chancellor sir was saying about property, so property is the central theme of this IPR. 3 words: intellectual property and rights. The central theme is property. Left side intellectual and right side rights. So what is property? Asti, sampattu. So what is the property means? Property can be divided into 2 types. It is some properties which you can see and touch and experience. They are tangible properties, which the laptop, which I am seeing by my eyes and I am touching and experiencing, it is tangible. And it is movable from one place to other. So in the tangible, again you have movable property and immovable property, like this university's building. So this cannot be moved from one place to other place. It is immovable property. So we all know about these tangible properties. But today we are not much interested in this tangible property for this workshop. So the workshop whatever we want to learn on intangible property. Means a property which you cannot see by your eyes, cannot touch and experience. So that property, among that, one of the property is intellectual property. So intellectual property, again, some intellectual properties which are mainly used in industries. Industries to flourish, they require that intellectual properties. They are, example, patents, trademarks, designs, GIs. And some intellectual property you are creating at your home or anywhere you can create it, they are interested academically also, or not only industries, even personally they can hold. If for a personal create prestige or record or whatever you can say, for that also some properties, they are copyright and related rights. Industries can also use that, but they are maximum used by persons to show in the society as a prestige. That can also be a property. So copyrights. So what is this 3 words? Intellectual property rights. Now when you come to the definition, a creative ideas and expressions of a human mind. So here is that left side word, that is intellect. Human mind. So intellect. Human mind, whatever it thinks and gets ideas into their mind. But it's not sufficient that getting an idea into mind is not sufficient. You have to express it. Express in any form of a product or process. So if you are getting an idea, by sitting here you may be getting so many ideas in your mind, because you cannot stop the brain. So it will be thinking continuously. So this getting idea is not enough. You have to express by using the resource and labor work, and that you can create a property which has a commercial value or value at the marketplace. And that property we call it as a intellectual property. And when you register it legally in your name, it will become right. So any creations of yourself, your mind creates that. That is intellectual creations. Any new products or processes created by human mind which has a commercial value is called as IP. And when it is registered, if it is not registered, it will be IP. You cannot say it is your property. And when you register it, it will be your property. So that is IPR, intellectual property right. So these have some characteristics which are similar to tangible, and there are also differences with the tangible property. All these intellectual property rights, they are negative rights. It means these are right against others. Negative right, I mean to say that these give right for not using myself or my progress. It is for the right against the other competitors. For example, if any one of you creates some new product, and with your efforts and labor work you are doing that, and when you release the product into the market, so you don't require a intellectual property right. So you have because you have created it, you have every right to sell in the marketplace. But at the marketplace, if someone sees that product, so it's obvious that he will be interested. Okay, I will also manufacture this type of product. And he will become next day competitor for you. So this competition comes from him, and he will become competitor at the marketplace. And that competition should be stopped. Then only you will get a good market share in the marketplace. So to stop that competition, you require a right against him. That is what the intellectual property rights will give. These are not for your purpose. Like, for example, if I am going and purchasing a car from the showroom, any company, Honda or Suzuki, whatever it is, do I require to register anywhere or not? Do I require anywhere registration or not? If I purchase with my money a car from the showroom, can anyone? Yes or no? Certainly, otherwise the police will catch where is the registration and all. So you need to register. So that registration will give positive right. With my money, I purchased a car to use for my purpose. I need to register. That will give positive right. But here, these IPRs are not like that. It is the opposite of that. So if you are making any creations by your intellect, by your mind, and if you want to use it for your purpose and let others also use it, then you don't require any IPR to be registered. But when my creation, I have a right and I should only sell at the marketplace, then I require to register. So that gives right against others. That is the negative right meaning. So this is an exclusive right. So that is monopoly right. So when you are registering, you will get a exclusive. Use it, not others can use for the commercial activities. So that is the monopoly right. All IPRs, and these are all territorial rights. Just now sir told about, so Edison's creations, and Edison's has more than 100 patents, not only in US and even international patent applications. But these all IPRs, they are territorial in nature. It means if you are registering with the government of India, it is only applicable in India. It is not applicable in US, where you have not registered. So if you want to get a right in other countries also, you need to register that country where you want to exercise this monopoly right. So all the IPRs, they are territorial in nature. And if I say a patent which is registered in India, so it is no one can use for commercial activities other than the registered person or licensee of that registered person. But same thing which is available in the internet, anyone can download in China or US or Australia. They can very much use that for commercial activities because that is not registered in that countries. So, and there is no world patent as such. There is a international applications you can do by sitting at Belgaum, and you can file a patent application throughout the world, but not the grant. You cannot get a grant by filing at one place. You have to file the same application in all the countries wherever you are interested. So that is the national phase applications which will give right in all the countries. So that is, there is a misconception. People will say, I have world patent. There is no world patent as such. In any country, you cannot get a patent for the whole world, because these IPRs are statute created rights. Parliament has passed that law, and which is created that right for some creators. Those who are creating it, they will get. But there is no possibility that you can get in one country and exercise in all other countries. There is no possibility. But filing is the facilitation for throughout the world, but not the grant. Individual country, you have to go and get. So that is, it is territorial in nature, and it is licensable. So you can license it. For example, if I get a patent in India, I can license either throughout the country, or I can give state-wise also. Each state I can give someone else as a license to manufacture and do the commercial activities. Assign it, I can sell it, I can mortgage it. Anything which I can do with the tangible properties, all the things are possible. Only thing is that you cannot see this. It's only a paper property. A certificate from Government of India, it is given to you in your name. You can say that I have this property in my name. But all other tangible properties, you can see that in, even though paper is there, you can see that also. But here you cannot see that. So that's the difference. So what is IPR in crux? Intellectual property, a brain which gets an ideas and uses the resources available and does the labor work. Without labor work, you can't do that. So that does the labor work to create an intellectual property. That property you can register it, it will become intellectual property right. So some prominent intellectual property rights which are governed are registered at the Controller General's office, from where I am coming. So there are 6 prominent IPRs. 6 different offices grants these 6, but they are working under the head one Controller General. So patents for the technology, industrial designs for the aesthetic creations, and then trademarks for the logos or symbols or words, names for a brand name. Then you have geographical indication of source, and copyrights and related rights, and for electronics, that hardwares, chips, SICLD, semiconductor integrated circuit layout designs. These are the 6 prominent IPRs which our office is administering. Our office is administering in India. Now coming to the importance of the IPR. There is a index for counting the ranking of countries among the world. The nations throughout the world, they will be ranked. and that ranking is called as, in the IPR field, Global Innovation Index. How the country is doing with the intellectual property rights, creations, registrations, and use of these intellectual property rights by the, whether it is the personal or companies or institutes, organizations, all the activity which are counted, all the IPRs are taken into account by the, who is giving these rankings? World Intellectual Property Organization, situated at Geneva. It is an office which exists in the WTO, so World Trade Organization. So this office will give the rankings every year based on the activity in each country. So last year, October 2022 October, the last ranking announced, India ranks among 193 countries, it is 40th rank. It is 40th rank. Though if you compare from last 7 years, it is progressing. It was 81 in 2015. Every year we are climbing to a 40th rank. But when we see that economic prosperity or economically or in other parameters, comparing with the other countries in the globe, is this a ranking of a intellectual property? Is it sounds good? Is it okay, 40th ranking? Are we doing less creations than many countries, even small countries? So we are counted at 40th rank. But if you see that, like in economically, India is 5th largest economy in the world. In most of the research activities, in publications and other, we are in top 10 research publications. But we are not in top 10 in Global Innovation Index. So there, 3 years back, we had a big discussion on this, where we are lagging. And Government of India has a task of giving this awareness to the people. That's why 2 years back we started with all the academic students or researchers, they must be aware of the rights, what they can acquire. So that is started with a National Intellectual Property Awareness Mission 2 years back. So last 2 years I was the in charge for Karnataka state, and we have almost covered at least around more than 1 lakh students and faculties in 2 years. So for giving the awareness to the colleges, institutes, organizations, just this ranking should be improved. We are not deserving this much low ranking as far as the scientific creations or activities are concerned. So with the aim, Government of India's aim is that in next 10 years, we need to be in top 10 of this Global Innovation Index. So how to come to the Global Innovation Index ranking at least in top 10? So that is with that aim only, we ran lot of awareness programs. And these awareness programs will give importance and interest creations to the creators who are really having a creations, but they don't know that so I can own IPR in that. That is the lack of awareness. Whatever the field, whether it is the health profession or any profession, even smallest of the small things also you can protect it. Whether it is commercialized or not, it is the first step before commercialization, it is the registration. If you are not registering, you cannot go for commercialization. Maybe even 10% also, it's a very good number if you are commercializing. So 10 out of 1, if it is commercialized, it is a very good one. So with that aim only, we are giving this in all fields of technology. It is very, very important, IPR. So this is not simply a ranking as a number. This has a lot to do for the economic benefit of a country. And export markets are depending on these creations, because in the globe, if you have a highest monopoly rights for a technology, you can capture global market very easily. Like what China is doing. So right now China is competing with US tooth and nail because they have started 30 years back. We were whatever position we are at now. So 30 years back China was in the same position, whether we need to give importance to IPR or not. So they gave importance to IPR. Initial 10 years, they have not done any good work. But they gave importance and they have given awareness, and with that only, now they are having every year filed with a more than 5 lakh applications, patent applications in their country. But if you compare India, though progressing gradually, last year we got a 22-23, we got 82,000 applications. In comparison to US or China, it is very small number. I hope in 23-24 we may cross 1 lakh applications first time. But domestic applications are our institutes. They are doing great work. It's not that Indians are not doing any research. We are doing, but only the reluctance, and we don't want to take benefit of the IPRs. That is the reluctance which is not good for the country's progress. So if anyone who is doing in the laboratory any creations, if they are filing, if it is helping the society in any way, whether it is a small or big, and that will be a success of that research. It's not research has to be in the as a thesis or as a project work. It should not be. It should be one or the other day, should help the society, small or big. You can, whatever you can do, so you can file, and if it is beneficial to the society, it can be easily commercialized. But if you are not filing and you want to go for commercialization, then you will be the loser, because anyone can easily copy that. Even though it is very good research and very good for the society, you will not get any benefit. That is the disadvantage you will face when you are not filing it. So whatever the project works you people are doing, it can be a protocol, it can be a procedure, it can be a test, it can be anything, a product, device, surgical instrument, anything. It can be a new and inventive. It can be filed to get a benefit out of it. So not only you personally benefited, your institute is also benefited, and in turn country is benefited. Because when you are going onto the global platform, so these monopolies will yield a lot to the country. So in crux, what I mean to say is that by sitting and doing at your desk, on your table, so you can make a economic prosperity of the country. You can be helpful for the progress of a nation. Ultimately, every citizen's duty that you need to do for the country good. So that you can do with a IPR protections. Creations are there. A lot of creations I have seen, but those creations are not coming for the registration. And that is the hindrance for the country's prosperity. So you people can know that these IPRs, whatever it is, whether it is a patent, design, trademark, copyright, all these things can help the country in a way to improve the index, global innovation ranking, and also it will benefit economically. So that is the importance, because we need to be among top 10 countries of innovators. So that's why this last year, that is August 15, it was the innovation was the mantra. So it was the government's aim. Innovation is the need of the country. So with that, I'll go to the individual IPRs, overview of IPRs. What is each IPR says about that. So first and foremost, you come to the patent. Patent is the important one, and it has a very little difference with a patient writing. If I put additionally one I, it will become patient. Many times we have seen letters coming from the people. Earlier it used to be the letters written to us either by post or courier. They used to sometimes mistakenly used to write patient office. So we used to become patient office. So this patent means an exclusive right, that is monopoly right, given to the applicant. Here I just want to say that not all creators will get. So only just I have created so many technologies. Unless you apply it, you will not become a patent owner. So whoever applies, he will become a patent. Just creations will not yield patent. That creations you have to write and you have to file it into a patent office, then only you will be rewarded with a right. So whoever applies, he will get a patent. What for? Limited period. He can exclude others. For all commercial activities, selling, manufacturing, making, using or selling the invention without a permission or without license. So who will grant this? Government of that country. Each country is having its own patent law. They will govern that and they will grant a patent in that country to the creators or innovators. So they will on a certain rules and regulations. But if you are filing, then only you will get. So it is your duty, not only creations, whatever you have created, you have to write that and file it. So then only you will get a grant of a patent. So what you need to do is that, so to get a limited period, that is 20 years from the date of filing. Like medicines will have an expiry date. Here also there is an expiry date, which is fixed on the day one. So today on 4th May 2023, if anyone files a patent, its expiry date is 20 years from today. That is 4th May 2043. Not a single day is extendable in India, because some countries have extension provisions, like US and all, they have extension provisions, but India doesn't have. It is 20 years fixed term. So before 20 years, you need to encash your research, whatever the creations you have done. After 20 years, it will become a public property. anyone can freely use without getting a license from you. So this government giving a right to you against others, against the competitors. It means if in a country, so of course we are just now became a #1 populated country in the world. So this country, in a one person is getting a right and it is against 1.43 billion population, you are having a right. Everyone comes to know that what is invention, but they cannot use it unless you permit them. So unless you give a license, no one can use. They are coming to know that what is the product, how to manufacture it, how to do that, how to prepare it, everything they know, but they cannot do it for commercial activities. So that is what, it's a great right you will be getting for 20 years from the date of filing. But this right is given by the government to encourage our researchers, do the lot of research work and do get a patent and enjoy the monopoly for 20 years against others. And in return, you need to do complete disclosure of the invention. So if you are completely disclosing it to the patent office, in turn patent office will publish to the public your creation, whatever it is there. So then you are rewarded with a 20 years monopoly for that. So what you need to do is that you have to write whatever the creations in one format that is there. In afternoon I'll explain how to write that. So in that format you have to write whatever the creations and you need to file a patent, and that will give you a 20 years monopoly right. What does the patent will help for the nation? Or the world? It avoids the duplication of research. Since already one person has patented it, the other persons may not try same research. Oh, he is already having a monopoly, or he is already published that I need not do the same research. I can just copy it. If it is not enforceable right, you can use it for commercialization. Otherwise, for research purpose, you can anytime copy it. There is no problem. So it also serves as an indicator in the field of technology. So it serves better products can be produced by patents, and indicator for achievement, like, so Dr. Hugar sir was saying that there are 67 patents which are filed by the university, and in that around 35 patents are already granted. It shows an very good, interesting research is going in this university, and they are all progressive and making the patents, and they can take the benefit of that patent by commercialization. So it shows this university is doing a lot of good research work. And the last but not the least, it records the information for future generation. So this is most important for our younger generations. All the information, whatever you have done in your laboratory, you can just write in a patent application and file it. So it will be recorded at one place for ready-made information for the next generation. We will never lose that information, whatever you people did in your laboratory, whether it is a PG project or UG project or the research project, PhD work. At any stage you have done something, you just give it to the patent office, it will publish in a journal, and it will never go away from that. Every time that records are there. You people may forget that you have done research, but others may use that information. So this is the most important thing. One has to look into that. Whatever I did in my lifetime, so if I file it, it will be there for generation after generation as a record. So this is required to develop a science. Whatever it is done, so you need to file it. some interesting ones. We have seen all this. I am not advertising Coca-Cola as a brand ambassador, so don't mistake me. So I just wanted to show that, so you can see this patent through Google also, you can get it. Ring pull can. It's a small innovation. If you see in India, many people, even illiterates, can also do this type of innovations. A ring only, just to pull open the can, one ring. And this inventor, he has invented, and he was aware of, fortunately, he was aware of a patent system, and he has filed a patent. And Coca-Cola company was behind him to give the assignment of this patent. They wanted to acquire this, but that person never gave it to Coca-Cola company or any other company. He himself held the rights. Instead, he has given a license to the company. So on a terms that 1/10 of profit sharing, whatever that can technology, that is ring pull can technology they are selling, out of the profit, the company has to share the profit with the innovator or creator. So with that, for 20 years on an average, this technology earned for the one inventor 1.2 crore Indian rupees per day. 1.2 crore Indian rupees. I have converted it into Indian rupees per day for I average for 20 years. Now you can imagine it. What was the creation? It is only a one ring. And this ring, it has earned him almost 10,000 crores in the patent's lifetime. So 1.2 crores per day, 1 month 40 crores, and approximately 480 crores per year, and it sounds more than 9,000 crores per year. Sorry, for 20 years. So that is the value. It has created a wealth to the innovator. If I say this type of innovation I have done, so people may laugh, hey, what is the great science you have created? So that is, it's not joke that, so you can see that it is the smallest of the small things also possible to patent and own as your right. We may not know that value of that creation, but when market accepts that, it is a great thing. Innovator has to anticipate whatever he has done, they have done a noble work. And that noble work, you can protect it, and it will definitely, if it is market accepts, it will reward hugely. So this innovator, if you would have been simply published, like we Indians generally have a habit of everything we publish it. If you would have been published, companies would not have paid even a single rupee. They would have been just copied that technology from the web journal, and they would have been enjoyed that. Even single rupee you would not have got it. So that is why importance of these technologies. It's not only you are benefited, your institute, your country will benefit out of it. So that is the importance of even small innovations. There are 400 paperclip patents. So if someone, I say, I have invented a paperclip, so people may laugh at me. Oh, in dod great science madidde anta. So this is small things. What patent office looks is that it's small technology, big technology, we are not bothered. Whether is there any advantage for the society? So like before paper clips, there were pins. So that pins To keep papers at one place, pins were used. But the pins were having a disadvantage that they were spoiling the papers. For long period, you cannot use it. So then people have invented these paper clips. These are holding the papers at one place, but they won't spoil the papers. This is the inventive step in the patent office. This is the innovator who has contributed for this, and a very small one, you might have just folded it and made it. But it is, there are 400 different types of these paper clips, they have made it. And they have patented it and they have sold it for whooping sum of 535 crores. So it is not the technology is big or large or small, it is the usefulness of that technology will contribute to the society or contribute to the inventor. So whatever you people are doing, even a smallest of the small changes when you are adopting any procedures in your laboratory, they are, if it is advantageous to the society, they can be protected. The other one, spin brush. It is automatic toothbrush. So it is battery operated toothbrush. A brush is fixed with a programmed chip and a battery. So just if you put on your teeth, it will brush it. So what the dentist will say, like that it will brush, zigzag, all those things. Of course, technology is making us lazy, but technology gives a lot of money to the innovators or creators. So this 4 inventors, they have invented and sold to the Procter and Gamble this innovation. So they don't want commercialize, let technology can be acquired by Procter and Gamble for a whooping sum of 3,000 crore rupees. So if I have seen myself when I visited under the NIPAM several engineering colleges, engineering graduate students, they have created such type of technologies in their project work, but they never patented and they never tried for this. Way back in 2010, 12, 16, they have created these things. So that's why we need to be aware of that. So there is a system which can benefit for the country. So when we protect it. So it may be taking our time to protect it, but it may be a reward for us also. If it is commercial success, it will fetch a lot of money to the innovators personally, and invention that innovator creations at that organization will be benefited. So if you want information more on patents, you can get in this ipindia.nic.in, that is Intellectual Property India. So Indian Patent IP Office, and WIPO, World Intellectual Property Office, that is organization, European Patent Organization, and US Patent and Trademark Office. So you can get a lot of information, those who are interested to get more on the patents. So this is one IPR among them, it is the patent. Now coming to the second intellectual property right, that is designs. Nowadays it is a lot of interest is created because of the online commerce or online shoppings. This type of technologies or designs. So there is no technology in design, it's only attractiveness to the human eye. So what is the design? The features of shape, you might have designed in such a shape, configuration, pattern or ornament, or composition of lines or color combinations. Anything which you have mixed to make it shape, configuration, pattern or ornaments, which are applied on 2-dimensional on a paper or on a article 3-dimensional. or in both forms also, 2D as well as 3D. So which is looking great, and that will be called as industrial design. So there is no technology, it's not advanced over the existing product for a usage of a person, but what is there, it is attractive. Like example, nowadays we are receiving a lot of design applications in the area of ornaments, jewelries, so many things which are new designs which are protected. Only thing is that you need to create a one new design. So it is attractive means it is commercially viable. So in this jewelry section or in the fashion designing, in fashion designing also lot of applications. Earlier we were receiving very few design applications, but now there is a huge number of designs. Every day we are getting lot of applications because of the competition in fashion designing and jewelry section. So this is another IPR. Those who are not doing any great science, they can also think of, okay, we can create some designs which are attractive in any things which are looking great, so they can be protected as a industrial designs. The third one, trademark. So this is the most used IPR in India. It is, we have seen lot of, when we are purchasing, we will definitely see the brand. So whether is it a branded or local, like that. So that is the trademark. So what is trademark? It is a word, name, it can be a company name or it can be a person's name, whatever it is, fixed on that product or service, symbol or device. Any combination of these things also, word, name, symbol, device, or sometimes its combination, which is used in trade with the goods or service to indicate the source of the good or service. So which company has made this product, to know by the customer, they will write some name. So that name, symbol, word, it is the trademark. So for example, a car which is going on a road written with a TATA. So it is manufactured by which company? Tata company. So Tata Motors Limited has the owner, a manufacturer of that company. So it gives a brand name for that. So if it is good, we generally see that brand names and purchase, whether it is online or offline. So Bata on a chappal or shoes, if it is written BATA, we know that this is a manufacturer of Bata company manufacturer. So like that, it will indicates that who is the manufacturer of that goods. And same thing with the service, like Airtel, Jio, they are giving service, telephone service. So like this, you can see that courier service, that Blue Dart, DHL. So these are the service marks. The fourth one, geographical indication of sources. So this is also a similar to a trademark. It is exactly like a trademark, but its difference is that you cannot personally, you cannot get a GI, geographical indication, for personal or company or institute cannot get. Only registered societies at that location, geographical location, they can get this. So what is GI? These are place names used to identify the source of the origin, source or origin of the goods and quality and reputation of the goods. So any good which is having that name, so it will indicates the quality and reputation. Like if I say Tirupati Laddu, so it automatically comes into our mind, there is some taste for that. So these are registered GIs, Tirupati Laddu, Dharwad Peda, then Ilkal Sari, Badgi chili. So these are having some its own natural or artificial, you can get for all GI. It's a name which indicates the geographical location. So this is also important that so it is only societies can take it. It's not the personal rights, GI. The next IPR is the copyright and related rights. So copyright, it is whether a person is having a right to copy or not. That is what it gives. Copying means it can be photocopying or downloading from the website. Anything it can be copying or copy pasting in the computer. So it is copy and write. So two words clubbed to make a copyright. So what the copyright gives is that it's older. If I get a registration of a copyright, I can prevent the copying of that material, whatever it is, whether it is a literary work, artistic work, musical work. So any type of work, I have created it. So they should true copy will be restricted. Photocopying or xeroxing of that is restricted. But it will never protect if I have written any protocol or test method or diagnostic method in that I want to protect it, it cannot protect it. It's only copying from xeroxing, or it can be a digital copying will be restricted. So many people have a misconception that if I copyright it, no one can use that technology. No, still they can use it for their commercial benefit. But it's only a copying is restricted. Xeroxing, or it can be taking a Xerox or copying digitally is restricted. That is what it gives copyright. So there are several works like literary works, movies, broadcasting, TV, serial, all these things, painting, software. So the last IPR is the Semiconductor Integrated Circuit Layout Designs, SICLD. So in laptop or computers or in mobiles, we see so many semiconductor integrated circuits. All these circuits, so they can register with us, but the difference from others is that they have to provide the product year. For patent, copyright, trademark, all these things, you need not worry about supplying any product to the patent or trademark office or copyright office. But here you need to provide a product to the office and they will certify, oh, it is good working, then only they will give a registration to the SICLD. So whether it is a transitory elements or layout designs of them, so you can protect it as a hardware component in the mobile or laptop or computers or any electronic devices. So that is semiconductor integrated circuits. So one of the IPR among the 6 which I am dealing today in a overview. So these 6 IPRs, if you want to see existing more than one IP, you can take in one product launch. For example, this is a, what is this? It's a, what is the product here? So laptop is there or not? It's a, so here Apple laptop, it is having registered or protected with 5 IPRs. That's why they are very successful in marketing in most of the countries in the world. So they have registered like LED display and processors, they have taken a patent for that. LED display and processors. And body of laptop, design of a laptop body, it is very attractive, so that is taken as a industrial design. And the sign, which is half cut apple, which is a trademark. So when they launch this product, they have made it as a their brand. So that is symbol with a half cut apple. And there is a user manual for this. So no one should copy that user manual. So they got a copyright for that user manual. And the layout, which is having the circuitry elements or transistors, so they have got the layout designs, SICLD. So all the 5 product, this is protected, they launch the product in the market. That's why we are not getting a duplicate version of this laptop. Though it is costlier, but people are buying that because of that quality or the brand value, whatever it is. But this is the advantage when IPR is protected. Any startup company which is nowadays they are launching, if they go with the protection of IPRs for a product or process or service, whatever they are giving like this, definite success will be there for that company. If a startup without protection, if they are going to the market, so they will be definitely a losers, because anyone can copy and compete with them. So this is the advantage, like Apple company is getting throughout the world, globe, they are marketing this without any fear of copying them because of protections only. If they are not protected, so anyone can easily make the duplicate versions. So this is the importance of IPR, is that they play like patents, science and technology, database development. Whatever you file, we are making a database. It is pool of a database. It will be helpful. And it encourages the innovators, do more and more research and get a patents, and rewards to them. As I have shown some examples like Ringpulcan or others, they got a huge money from the innovators, and you can make a profits by commercialization. So many companies nowadays started, whether it is a graduations or PGs or any even a student who has done a great work, so they can also become an entrepreneur for their products. If they have a 1 or 2 patents, they are confident that it will be marketable, so they can just create a startup. Government of India is funding lot of funds to the startups, and they can become a self-employed, and they can give employment generation to others also through that. So with the IPR, you can just create a startups, and those startups will earn the money for them. So with that you can make. So generally, if you are going from laboratory to market through these 3 steps, then it is advantageous. For a stages of development, if these 3 are there, then you are most advantageous than the others. Like you are fostering innovations, you all do creations at the laboratory, and then you need to protect it through a proper IPR policy of the institute. And with that protection, if you are going to the market, you will be rewarded hugely for the commercialization of that protected intellectual properties. Whatever the IPR you obtained, you market it through commercialization, whether yourself or you give it to the other companies, they will do it because of the protection that will protect the market's interest or person's interest at the marketplace. So that is the advantage. But people in India, many times they will do innovative products and then skip the second step and go to the third step, commercialization. And after certain period, it will boomerang on them. So many people will copy and sell the products, and they will become competitors for them. and ultimately the original innovators market share will shrink. So that is the danger when you are leaving this IP protection. IP protection plays a lot of importance when you give importance to them. When you give importance to that, it will definitely protect you. So you protect them, they protect you. It is a in turn. So this is what I wanted to say as a overview of IPR. So in the next I will give the this other things which are required for the patentability requirements. So any questions on this overview of IPR? If anyone wants to know about anything, let us make it as an interactive session. It will be very good. Yes, ma'am. Yeah, copyright penalties as per the Copyright Act 1957. See, first you need to have the copyright infringement. Definitely it is not in monetarily, it may not be that much heavy because they have to analyze the damage which is caused to the owner. So we are generally infringing the copyrights on day to day, whether students will xerox the books which is written by any authors, that is by default it is copyrighted, and which we are, so when we assess the loss to the owner, so then only the penalties will come as a damages. And all these IPRs except this copyright and trademark, they are all civil rights. Civil right means you have to sue to the court and court will decide how much damage to be allotted as a civil suit. In criminal suit, all the goods will be seized if it is a criminal. In trademarks and GI and copyright, if you are registered copyright. If you are not registering, it's only a civil right. So there the damages will be awarded generally by the courts. But the act will provide you misrepresentation of copyright. You don't have a copyright or it is not your work, but you are misrepresenting that. So there is up to 10 lakh the penalty will be there for that misrepresentation. But damage is assessed case by case, how much it is the loss to the owner, and then it will be awarded to them. So example, patent I know, or the copyright, like I think people might have heard about this SP Balasubramaniam's and Ilayaraja's case. So Ilayaraja was composing the music and or the lyrics, and SP Balasubramaniam was singing those things in commercial events. He is getting a money from that. So Ilayaraja filed a case, civil suit, on because I have a copyright on those things. So you need to pay whenever you sing a song which I have composed it. So there was some damages which was awarded to the Ilayaraja. So, but in patents, like Micromax has paid to the Samsung around 100 crores damage in one patent infringement. In patents, almost there are in crores only, maybe 100, 200 crores like. So, but in copyrights, it is the less because the damage is less.
So damage can be in the form of loss in
monetary loss, prestige loss, all these things will be there. So court will analyze and award the rewards.
Yes, sir. Thank you.
Yeah. Yes, yes, sir. Please.
We hear about the utility patent and plant variety seed plant,
Yes.
which
Yes.
when there are other two. Does India encourage utility patent and PVPR?
Yes. So utility patents right now it is not there in India, but US, China, Japan, Korea, they have these patents, utility patents. That is short lifespan, that is 10 years lifespan patents, and it is only a novel thing. It's not having a inventive thing. This is just to encourage the small scale industries. They have that. We are also trying to bring that law, that is utility patents, in our Patents Act, but government still it is verifying that whether is it a boon or bane, like that. There is a committee is constituted. We have drafted a law for the utility patents by seeing this Chinese and Japanese Patents Act, but so Indian government is a little bit reluctant. It may boomerang on our small scale industries, or it can be a beneficial also. So they are now quantifying that how much it is beneficial to our country. So that is utility model patents may be possible in future, but right now it's not there in India. Second, you asked about the plant varieties. So as a Indian government agreed sui generis mechanism for the plant varieties protection. So we have as a PBRs, that is plant breeders' rights. So by breeding, our farmers or anyone is producing the hybrid varieties of a plants, we are not giving patents for the hybrid varieties of a plants or animals. Only the breeders' rights we are granting under the PPVFR. So it is administered by the Indian Council of Agriculture Research. ICAR is looking. There is a chairman for PPVFR. So that is the farmers' rights and the breeders' rights are clubbed to make it as a plant breeders' rights. So it is awarded by the Indian Council of Agriculture Research. So it is not with our office. That's why I did not cover this IPR actually. So there are several other IPRs also apart from these 6 IPRs, but that is one of among that PPFR. Seed variety, rice variety, any plant related things, they comes under the PPFR.
So they are not patents.
They are not patentable in India. You can get a patent in US. Plant patents are there in US. You want patents, you have to file in the US Patent Office. But in India, we are not granting patents for the plant varieties or seed varieties or any breeding technologies. You have to get a PPFR only.
So suppose somebody develops a salt resistant rice variety so that coastal belt can be utilized.
Yes.
So what is the benefit that he will have in terms only protection?
Yes, that is also protects, but not as a patent. There is a limitation for the patents that PPFR rights. See, there is patents, as I said, you no need to show a product to us. You just write on a paper and give. But to get a PPFR, you have to supply the seeds to them. They will test at least 3 years in the field. If that whatever the variety you are saying, character you are saying, it is stable for at least 2 to 3 generations, then they will award you the rights. So that's why testing is required. So it's not possible in the patent office on a paper. But in US, genetically modified plants, they are giving a patents because if you just show the process only. So there you can get it. In India, genetic modified processes we are granting, not the plant patents or seed patents. There is no possibility. Like BT cotton, it is the process they have got a patent, not the BT cotton seeds or BT cotton variety. So they have registered with the PPFR. So that is what one case was there on Lay's companies, Pepsi. So they have registered a PPFR in the potato variety. So that gives very good for the crispiness of the chips. So people, they have taken the seeds from the other farmers and they have grown and they were selling in the market their potatoes. Then that Pepsi company has sued them in the court of law. Now we have this potato variety is protected as a PPFR. So still the case is going on.
Sir, does the expiry apply only to the patents or designs, trademarks
So
as well?
patents is for 10 years expiry from the date of filing. Designs generally 10 years, extendable by 5 years, 10 plus 5. If you want extension, you have to file with a fee, then it is extendable 5 years. Trademarks for that is infinity period. You can own any more time, only 10 years once you have to renew it. GI is same, 10 years once you have to renew it. For copyrights, there is a timelines. So some works, literary, dramatic, artistic works, life of a author plus 60 years period is there. No one should use that. For broadcasting like serials, all these things, movies, they are 25 years period from the publication year.
Sir, you said patent 20 years and presently it is not renewable in India.
No, extendable, not extendable, but you have to renew third year onwards up to 20 years if you want to maintain the patent. Every year or at a time 18 years you can pay the renewal fee. Like for first 5 years 500 rupees per year the fee will be, and next onwards 1000 rupees, next 2000. So the last 4000 will be there, last 4 years. So like that
4 times?
no, not 4 times, 18 years. You want to pay at a time 18 years you can pay it. First 2 years we are not charging any renewal fee because we take at least 2 years to grant a patent. Third year onwards you have to pay the renewal fee up to 20th year if you want to maintain patent.
Okay.
Yes. Any questions?
Sir,
Yes.
for nationally, some Indian patent has been applied and not applied internationally in another countries. They have used, they can use. So can again they can apply there and restrict there, or it will not be applicable then?
So there are timelines, sir. International application, as you asked about, see, I filed today in India on 4th May 2023. You have up to 1 year time to make an international application. Within that 1 year, you have to make, or international application you don't want, you have another route, that is conventional route. So you can go whichever the country, like I want to file at US. Within 1 year, if you are going and filing patent in US PTO, even that also you can do online. So they will recognize Indian patent application date, filing date as a 4th May 2023. Within 4th May 2024, you have to file it. So after 1 year, if you go, they won't recognize this date. There is a 1 year under the Paris Convention Treaty. So you need to be bound by that timelines. If you are interested, you can either make an international application within 1 year or file a conventional application, whichever the country you want to file, you can file it as a conventional application. Those timelines missed means you can't file again the same application because we published that application here in India. If it is published, it is a public domain knowledge. So no one can take patent on the published information.
They can't take, but they can prepare, no?
They can use same thing. See, in US, every year more than 5 lakh patent applications. Among that, around 40 or 50,000 they will file in India. So rest 4.5 lakhs are free. Indians can copy from that. So we are also having that advantage. They also have a advantage. So it is vice versa.
Sir, now we'll break for the tea, sir.
Okay, sir.
10 minutes will be given for tea break. So all of you can gather back here for second lecture. And afternoon there will be questionnaire session. So all of you can come out with your idea, and also any questions are there pertaining to your patents or any other IPR activities you can ask. And the people who are there online also, I request that the questions will be taken directly from the online also. Wherever the clinical people are there, they are treating patients, they can come online and ask the questions and make use of this IPR activity. Thank you.
The tea is arranged outside.